The property research revealed that James and Melanie Nipper are indeed the property owners of parcel 23-5N-2000-001-0000. Copy of that property appraiser's printout, as well as a request for what the land use designation was, a request made by Officer Alford to the Planning Department, which categorizes this property as large-scale agriculture. That would be Exhibit 2A and 2B.
Have you shared these with Mr. Gates? Do you object to the introduction of this?
No, sir. If I have an objection, I'll state it.
Okay.
So that we can have a nice flow.
Okay, great.
I've not seen these before in this proceeding, but because there's currently pending litigation, I'm familiar with the documents.
Okay. You let me know if you object to the introduction of any of them.
Thank you, Mr. Chairman.
Go ahead.
All right. For several months, there was nothing, no activity reported concerning the skydiving operations, but on October 6, 2012, code enforcement received another complaint about the same type of activity concerning a commercial skydiving operation. Officer Alford did a reinspection and found that there were in fact skydivers jumping out of the airplanes. There were also several vehicles parked at the hangar, and research of the website as advertised of skydivelive.com found prices for the skydiving operations, directions to leading to that location, and confirming of the commercial activity taking place. That would be exhibit. I'm going to have to change the exhibit numbers on these. So what are we at, 3? Yeah, but because we took some of the exhibits out. So this is going to be exhibit 3A through H. It will also include a copy of a notice of violation that was sent to the Nippers, and proof of their the green cards, proof of their receiving that. There were several conversations and discussions going on over the last couple of years. In 2000 and the end of 2012, there was a code enforcement was directed by staff, by legal counsel at the time, to close the case pending an appeal that the Nippers were making to the Board of Adjustments, which is partly why you see a delay from the original case of 2012. It was closed the original case was reopened in 2013 after we received another complaint of the same activities going on. And so on the last inspection that we made there on the property to the site was in May of 2014, where I went out and did a reinspection. So we want to submit exhibits 4A through C, which are 3 photos from that inspection, and that's from May of 2014.
Mr. Chairman?
Yes.
Would it be easier for the board if we simply stipulate that the Nippers are engaged in commercial skydiving activity on their property?
That's the last of what we got.
Very well.
So you're so stipulating, Matt, for the record?
Yes.
Okay.
On December 18th, a notice to appear was sent, certified mail, to James and Melanie Nipper at the address of 5138 County Highway 0605 to Phoenix Springs, Florida, 32433, for tonight's hearing of January 15th, 2015. That would be Exhibit 5A through D.
And this one, Jason, that's labeled 9A, that's going to become 3
That will become 4,
or 4?
right. And I apologize for the misnumbering of the exhibits.
So the one labeled 4 is 3.
No,
Yes.
there- And this one then labeled 11 is 5.
Yes.
Okay.
The last exhibit that we have is a letter from Planning Director Wayne Dias directed to the council at the time of the Nippers regarding the permitted uses for their property and clarifying that the operations of the airport was not a permitted use. And that would be Exhibit 6.
Here, I think you can pass them out.
That's all the exhibits that we have. Would like to do, if it's all right with you, Mr. Chairman, is read the finding of facts, inclusions of law, and final order.
Yeah, please.
This is case number.
Wait, hold on. a
Hang
minute.
on one second.
What's the matter,
Mr.
Mark?
Chairman,
Yes.
I believe everybody stipulated, but you need to formally say you've accepted all these exhibits into evidence.
Okay. All these exhibits, that is to say 6 of them, have been formally accepted then into evidence.
Thank you.
Mr.
Yes,
Chairman,
Mr. Gates.
I'm sorry, I may have been confused by the numbering. The findings of facts and conclusions of law, has that been given to me?
No, this
No.
is not an exhibit. This is just would be the final order.
This is what he's suggesting
Right.
he wants us to do.
Oh, I understand. Thank you, Mr. Chairman.
Yeah.
Sorry. This is case number 12-172, Walton County Department of Code Enforcement Petitioner versus Melanie and James Nipper, respondent. Finding of facts, conclusion of law, and order. This case comes from, for public hearing before Code Enforcement Board of Walton County, Florida, on January 15, 2015, after due notice to the respondent and the Code Board, having heard testimony under oath, received evidence, and heard argument, hereby issues its findings of fact, conclusions of law, and order as follows. The respondents, Melanie and James Nipper, whose mailing address is 5138 County Road 0605 to Phoenix Springs, Florida 32433, is the owner of the property described as, it's the legal description of the property, also known as 5138 County Road 0605 to Phoenix Springs, Florida 32433, parcel ID number 23-5N-2000-0001-0000. The following conditions exist on the subject property in violation of Section 2.01.3A1 and Section 11.00.00A of the Walton County Land Development Code. The respondents received administrative notice on October 11, 2012. The notice advised the respondent that the condition of the property constituted a violation of the county code. The respondent was provided a reasonable time to correct the violation with a compliance date of October 30, 2012. Respondent failed to correct the violation on or before the compliance date. The county has incurred administrative fees of at least $450 on account of prosecuting this code enforcement violation. Conclusions of law. This is a lawfully constituted code enforcement proceeding convened pursuant to Chapter 162, Part 1, Florida Statute, and Chapter 12, Walton County Land Development Code. The Code Board has jurisdiction over the subject matter and the respondent. Notice of this proceeding has been duly provided to respondent as provided by County Code. The respondent, Melanie and James Nipper, by reason of the foregoing facts, is in violation of Section 2.01.03A1 and Section 11.00.00A of the County Code. The respondent is subject to the enforcement jurisdiction of the Code Board. the order. Based upon the foregoing findings of facts and conclusions of law and pursuant to authority granted in Chapter 162 Florida statute, by motion made and duly seconded and passed by the Code Board by a majority vote, it is hereby ordered the respondent is to correct the aforesaid violation on or before January 22nd, 2015. The respondent is further ordered to contact the Walton County Code Enforcement Department to arrange for reinspection of the subject property to verify compliance with this order. In the event that county staff finds that the aforesaid property is not brought into compliance after January 22nd, 2015, the respondent shall be ordered to pay a fine in the amount of $250 per day per violation until the property is brought into compliance. Assessment of such penalties shall be provided by law. An administrative fee of $450 is assessed against the respondent and shall be paid on or before February 15th, 2015. And that's the end of that there. So.
Okay, let me ask you, I'm a little unclear here. The first complaint was in April of 2012. The second complaint was in October of 2012. And then you said that they went to the Board of Adjustments, and then nothing happened until 2014?
I believe they began operations again in 2013, which we reopened the case at that time.
Are we party to what happened at the Board of Adjustment?
Yeah.
Yeah.
Essentially, the NIPRS sought a review of a determination made by the planning director with regard to the allowable uses in the property. The Board of Zoning Adjustments determined that that appeal was untimely, so no action was taken. So the findings of the planning director were essentially a stand as he made that interpretation. And this code violation, and I understand it, is primarily based upon the planning director's interpretation of the code and the comp plan, and Mr. Dice is here to explain the basis, which is actually set forth in Exhibit number 6, which has been introduced to you. So no action was taken by the code, by the Board of Zoning Adjustments. It's my understanding that the NIPRS had resumed operations sometime in 2013. That's when the new complaint came, and that's when this case was reopened.
And it's taken a year and some to get here?
Apparently.
Okay. Does anybody else have questions for Mr. Catalano?
Did they continue? All right, so they went before the Board of Adjustments, but no action was taken. Did I hear that correctly?
Board of Zoning Adjustments determined that appeal was untimely, so that the prior decision of the planning director stood.
All right, and that was 2008?
No. 2013.
2008 was the TRC meeting. Is that correct?
Right.
The initial TRC.
Right.
So what transpired between 2000 for those 5 years, give or take, between? Did
Essentially,
they continue to run
the NIPRS sought essentially an updated opinion from the current planning director as to the allowable uses on the property.
Okay, because this letter, Exhibit 6, says that there is an attachment that's not here indicating, I guess the minutes of the TRC meeting
Right.
indicate. Okay, but there was a 4 to 5 year, I guess, gap in time that they continued to run the business.
They ceased for a period, and Mr. Gates may can speak to this, but they ceased for a period of time, sought this review process to the Board of Zoning Adjustments after the notice of violation had been issued. Then the Board of Zoning Adjustments determined that that process was untimely, so that the planning director's decision stood, and then the new complaints occurred in 2013, which triggered this being put back on the table, essentially.
Okay.
And there's not the opportunity at this stage, when it reopens, to appeal that to the Zoning Board of Adjustments?
Right. I mean, essentially the determination of the Board of Zoning Adjustments was that the appeal was untimely. There was not another bite at that apple.
Okay.
And they can't do that again now in a timely manner? Could they go to the Board of Adjustment?
It's my understanding not. Mr. Gates may differ, but it's my understanding not. And the matter, as Mr. Gates had indicated at the beginning of this, this matter is in litigation. I understand it's set for trial next month in circuit court regarding some issues that I expect Mr. Gates to raise here shortly.
But in spite of the fact that it's in litigation and there's going to be a trial, we're called upon to make a decision?
Yes,
And it's, I assume, litigation between the Nippers and Walton County?
exactly.
Seems like we'll proceed. Hey, but let me ask one last question. Is this a repeat violation, or is this a new?
No, it's my understanding that this is essentially, I mean, the file was closed back in the 2012 time frame, and when the new complaints came in 2013, after the Board of Zoning Adjustment process was over, this file was essentially reopened. So it's as I understand it, it's not a repeat violation.
Okay. Any other questions?
Yes.
Yes.
Jason, when you were speaking, you said the land use was. Has the land use changed?
No, I apologize. No, the land use hasn't changed.
Okay.
It's still large scale.
It's the same now as it was then?
Yes.
Okay.
Okay. Are we going to? Do you want to ask questions of Mr. Catalano?
Mr. Chairman, if it's acceptable to you, I'd like to examine Mr. Alford, as he's the one who sent the notice of violation to my client. It's his signature.
Mark, is this appropriate to do that now?
Absolutely, he can call
Yeah,
it.
go ahead.
Mr. Katz, could you come up to the microphone when you speak, please? Thank you.
Jason, would you come up as well?
Excuse me, Mr. Chairman,
Yeah.
can I just have one word of private, Mr. Gates, just one second?
I hope the judge agrees with this. I hope the judge agrees with this. Seems kind of like necessary.
Thank you.
Mark, did you swear everybody in or just?
I was going to do it one at a time.
Oh, okay.
Okay, would everybody who's going to testify in this affair stand, please, and be
Yeah, I will go ahead and do it.
sworn in?
Everybody who participates testifying tonight, if you stand and raise your right hand, what the swearing in laws advance. I've had a long one. Do you solemnly swear or affirm the testimony you would give before this board will be the truth? Thank you.
Mr. Chairman, where would you like Mr. Alford to be as I ask him?
Are you going to ask Mr. Alford if he'd come up to?
Yes, sir.
Yes.
Mr. Alford, I just have one question for you. On the exhibit that is the October 11, 2012 exhibit, I must confess I lost track of the numbering early on. You identify the violation in your second paragraph as specifically you are operating a commercial airport in a land use that does not support the activity. And you continue, also, you do not have a development order for the commercial airport. My question is, what is a commercial airport?
I apologize, my voice. I thought I was out of hand.
Yes.
Measure commercial airport would be something to serve monetary value or have profit. So we found that they were made profit by the airport.
Mr. Alford, I understand your condition, but Mr. Gates, if you could repeat what you think Mr. Alford said, that would clarify it for us and we'd know you understood him.
I'm sorry, Mr. Chairman, I was not able to understand Mr. Alford.
Mr. Alford has, we all understand, okay. If, I guess what he could do is write an answer.
Yeah, Mr. Chairman, I would have no objection if Mr. Alford would like to write an answer to that question. It will be my only question for Mr. Alford, so we won't have a protracted writing exercise.
Mr. Alford, would you be willing to write what you've said?
Which one was the question? He said, which exhibit was it? Oh, I noticed that too. It was something that I wrote down. When he was talking, he said the complaint was for a commercial airport. And then he jumped from that into...
Mr. Chairman, I'm sorry, have you concluded, Mr. Alford? Okay. Mr. Alford has written receiving monetary gain. I assume, Mr. Alford, that means receiving monetary gain for putting people in an airplane. Is that... Okay, and let the record reflect Mr. Alford has indicated affirmatively.
Okay.
Thank you. That's my only question for Mr. Alford.
Okay.
Mr. Chairman, if it's okay, I have a binder with the exhibits that I'd like to present to the board. Would it be okay if I gave those to Mr. Davis so that he could hand those out to the members and of course, to opposing counsel as well?
It's fine with me if Mr. Davis doesn't object. Okay, are you, is the county done? No.
Oh, I'm sorry, I thought you were done with the presentation.
Actually, I was going to permit Mr. Dice to explain
Oh, okay. His decision.
his interpretation.
Yeah.
We'll see.
Very well.
Okay.
On my fault.
Good evening. Essentially, what I did in my letter of December 26, 2012, was try to give the county's position as far as the operation that was being conducted there. The importance of the 2008 issue when it was before the TRC is that item was they had, I believe it was Skydive Live, I believe they had were making application for a development order to have basically an airport. I was not present at that time, but the minutes reflect in the TRC minutes that essentially the plan director notified the applicant that that land use did not support that activity, and it was removed from the agenda. It was our position that when that was done, that the director made a determination that that land use did not support the activity that they were seeking, and that was a determination. That was never appealed to the Board of Adjustments or anything else. And that issue was brought forward again to the Board of Adjustments in 2013, I believe. And at that time, the Board of Adjustments 2013 said that issue's, and if I'm wrong, Bill, let me know, that issue's already been handled, and we will not revisit that issue again. And so the board upheld the determination that was made in 2008 that operation was not allowable in the large-scale land use. And the majority of my letter basically outlined that. I went on to describe why I felt like that land use was not compatible with the large-scale agriculture, the activity. Obviously, as we all know, there's several land uses that are allowed in that large-scale ag that are related land uses, and those are given. And I believe the language is shall be limited to, and it gives several land uses that I might could read them to you, I guess.
Yeah, let me direct you to first of all, one of the code provision addressed in your letter being 2.01.03. If you can refer to that.
And in that section of the code, it gives the primary uses, and then it considers functional agriculture related non-residential uses. And so that, then we refer back to the comprehensive plan. And the comprehensive plan gives a little more broader, I believe, a little broader definition of what those are.
And your basis for referring back to the comp plan is based on code provision 1.06.02?
Exactly. The Land Development Code gives some guidance on how to interpret the Land Development Code, and it essentially says that, and I'll read part of that to you. Other provisions of this code, the Director of the Department of Planning and Zoning shall be responsible for interpreting and shall look to the Walton County Comprehensive Plan for guidance. And that's what I did in this case, because the Land Development Code basically said that, that functional agriculture-related non-residential uses were allowed, and then if you go to the comp plan, and the comp plan is policy number L-1.4.1 under large-scale ag, and it goes on to list supporting agriculture and silviculture commercial uses shall be limited to the following. And it gives a series of those: farm equipment sales and repair, kennels, veterinary services, sale of agriculture chemicals and supplies, rural neighborhood, general or grocery store, feed sales, blacksmith and woodworking shops, processing, storage, or sale of agriculture products, outdoor recreational activities such as hunting or fishing camps, bait and tackle shops, shooting ranges and golf courses, travel trailer parks or campgrounds connected to outdoor recreational uses, riding or boarding stables, cemeteries, communication facilities, small engine repair, and welding shops. And it's our position that those uses that are given and shall be limited to the following are not consistent with a skydiving operation.
And you heard counsel stipulate that the activity on that property? Yes?
Yes.
And in your opinion, is that use compatible, or is that supported by the land use large-scale agricultural?
It is not.
That's all the questions I have. Mr. Gates may answer.
Thank you. Just one question, Mr. Dias. Do you have a definition of commercial airport that is different than the one Mr. Alford provided?
A commercial airport, mine would be a little different than Mr. Alford, I believe, what I would consider a commercial airport. I think that a commercial airport basically speaks to the level of activity there. We all are aware there are several smaller, what I would consider private airports that are solely for the purposes of leisure activities where there's no monetary income, and it's really for the use of the owner only.
So your department has cited my client for violating the code by running a commercial airport, and you and the person who wrote the violation have different definitions of what is a commercial airport. Is that the correct understanding of your testimony?
I believe that the issue at hand tonight is a skydiving operation.
Okay, you testified to that. It's not really my question. My question is, if we are here to determine specifically whether or not the Nippers are operating a commercial airport, do you and your employees have a different definition of what constitutes a commercial airport?
As I said before, I agree in part with what Mr. Alford cited as a commercial airport. Obviously, you're taking revenue, it's an income-producing type activity. And so I agree with that portion of what he said.
So if you agree in part, does that necessarily mean that you disagree in part with what Mr. Alford said?
I don't necessarily disagree. I think there's more to that explanation.
Well, okay, so Mr. Dias, either you have the same view of what's a commercial airport or you have a different view of what's a commercial airport. Which is the case?
Like I said before, I believe that my way I describe it's a little more expanded than what Mr. Alford said, which includes part of his definition.
No further questions.
Anyone on the board have any questions of Mr. Dias? Wayne?
I do too.
Robert, go ahead.
When you gave a list of examples about what could happen on that property, was that where you mentioned RV parks and things, are those functions that can occur or not occur?
That per the comprehensive plan, the land development code, can occur.
Can?
Yes, sir.
So they could operate a campground, they could operate an RV park, they could have a riding school?
Correct. And that is purely based off the comprehensive plan guidance that's stipulated in the comprehensive plan.
Now, let me ask you a question. If that was farmland and the owner had an airplane and a runway, could he operate his aircraft off of that land, either to herd cattle, hunt deer, or spray crops from that property?
I think in the example you gave, if that use was directly related to the operation of an agriculture activity, then, speculatively, I would probably say yes, that would probably be allowed.
Okay. So the question goes back really to whether or not, it's not a question whether an airplane is operating off the property, it's what is that airplane doing? Is that correct?
I believe so, yes.
Yeah, okay. Last question, and maybe this is for Mr. Getz. Is this operation run as a club? In other words, do people pay dues? Are there members in this club?
Thank you. It is a fee-for-service activity in its current form. There are people who regularly attend and regularly pay for that service, but it's fee-for-service.
But it is not a parachute club in the term club?
No, sir.
Okay, thank you.
Mr. Folks.
Mr. Dice, you mentioned again the TRC minutes as you spoke. That's the second time that's come up. Do we have a copy of the TRC minutes?
If not, we can get those. It's from 2008. Yes, we have a copy of those. Should we pass around and make them an exhibit?
I mean, we've got a letter here that says they're attached and they're not, and then...
I'll mark this as Exhibit 7. We can read it.
Maybe we ought to make it 6A, be more logical.
6A?
Yeah.
Okay.
And Mr. Folks, the copy we're glad to give you, but on number 7 of that is the Skydive Live drop zone application. And basically it says that Director Blacksher noted that she had spoken with the applicant by phone and explained that the planning department could not approve this project in this land use category, and that the applicants had therefore withdrawn the project.
Okay, thank you. One other question. One of the things that you read out in that description of what was allowed was outdoor recreational activities. Would you say that parachuting or skydiving is an outdoor recreational activity?
No, sir, I don't believe so.
How would you describe it then?
And I'll tell you why. If you read the comprehensive plan, it says outdoor recreation,
I'm not asking you about what the, you know,
Right.
I understand that I'm just asking you in general because the comprehensive plan said outdoor recreational activities are allowed.
No,
Okay, go ahead.
Not exactly.
it says
All right.
campgrounds connected to outdoor recreational uses. Or campgrounds connected to outdoor recreational uses. It doesn't say recreational uses, it says campgrounds connected to.
All right, thank you.
And Mr. Folks, if I could go, it says, I mean, this is how I reinterpret this. It says outdoor recreational activities such as, so the conference plan is giving us guidance, such as hunting or fishing camps, bait and tackle shops, shooting ranges, golf courses. And so when I read that, I'm looking for like uses as those. And so as far as skydiving, I don't believe that is a like use that is in the same grouping as those.
Right, yeah, the first part of the sentence says supporting agricultural uses related to outdoor recreational activities. So it's saying outdoor recreational activities. I mean, I'm just not sure how you would classify skydiving if it's not an outdoor recreational activity.
And Mr. Folks, quite frankly, and not to seem cute, but I believe this decision was made in 2008 by the previous director. When she said this use is not allowed in 2008, she said that, and that decision stood. We stand by that decision, and quite frankly, I think when that was made, that decision was not appealed, so it stands.
I understand all of that, but I'm not just going and looking at what she said and just going, okay, because Ms. Blacksher said that's the end of it.
Right.
I think we're here to kind of review the cases that are being put forward, and that's part of it. But I also, it's my understanding that, you know, outdoor recreational activities are, it seemed to be, allowed in this agriculture setting. And when I asked you if you thought it was, and skydiving was an outdoor recreational activity, you said no. It's a little perplexing to me.
When I say it's no per the conference plan, you have to look at the conference plan.
I'm just asking you straight out, is skydiving an outdoor recreational activity?
Under the conference plan.
No, I'm not. I'm not.
My personal opinion, I don't believe has any bearing in this case.
Okay, that's fine.
But because I have to interpret based on the land development code and conference plan. I can't exercise my own personal judgment. I have to use what's been given in front of us. And when I do that, I have to look at what it says. And it goes on to list. It says such as. And so I have to use that such as these are the groupings
I agree.
that are going to be allowed.
I agree.
And when I read those, and then you try to add in there a use that's not listed, first of all, and a use like skydiving, the intensity is different.
When you say it's not listed, I mean, it just says such as. It does not purport to list every activity that's allowed.
But I believe the activities we have here are not on the same level as a skydiving operation.
I'm not sure what that means. They're not on the same level. But
Not on the same intensity level as a skydiving operation.
intensity level?
Mm-hmm.
Okay.
Okay.
Thank you.
Then, Mr. Gates, I believe it's your turn.
Any more questions for him? If staff has no more witnesses or evidence.
Okay, thank you. You're going to give those to Mr. Davis for distribution.
Matt, just quickly, Bill, have you seen all these exhibits yet? Or?
No, I have not.
Okay, we may just go through them all. Let him look through them real quick. We may just admit them all at one time to see if you don't mind.
If you'd like me to pause and allow Mr. Warner to look through them, that'd be fine.
Mr. Chairman, I've reviewed the exhibits 1 through 17 offered by the Nippers. I would, and I understand the rules of evidence are not strictly interpreted here or utilized. With regard to Exhibit 17, could be a grouping of letters or affidavits from various persons supportive of the Nippers' position. I would object to those on hearsay grounds. Otherwise, staff has no objection to the other documents presented.
And Commissioner, essentially, what those are hearsay statements that are not part of, in other words, they're not here to testify tonight, I assume. So some may be. You can admit them, but you cannot, unless they testify, you cannot rely on them to make the decision. In other words, they're admissible and they're evidence, but you cannot base your decision solely on those hearsay statements. If they testify, that's different. So I would suggest you accept them into evidence with that understanding.
Okay, then we shall do that.
Mr. Chairman,
Go ahead.
am I okay to proceed?
Yeah.
Mr. Chairman, before I begin with my substantive argument, I had a question that perhaps you or Mr. Davis could answer for me. Section 90502, dealing with membership of the code enforcement, seems to indicate that the membership shall include one architect, one business person, one engineer, one general contractor, one subcontractor, and one realtor. I'll confess I don't know all of your backgrounds. I simply wanted to know whether or not all of those had been fulfilled for the sake of our findings today.
One architect, one engineer, one subcontractor, one citizen. Who are you, Robert? Citizen.
And one general contractor.
And realtor.
Very well.
And
Thank
broker.
you. All right.
Can we do that? Can dual purpose?
Yes, sir.
Oh, okay,
Okay.
great. I'm a contractor as well.
Very well.
Okay.
Understood. I simply wanted to ask the question, and I know that the notice to appear at this evening's hearing was a notice to James and Melanie Nipper. I simply wanted to note for the board that I have Mr. Nipper here. Miss Nipper is currently deployed in Africa, and I've explained that circumstance to Mr. Davis and Mr. Warner, and that's the reason she's not here. I didn't want the board to think that she had ignored the order to appear.
Thank
you. It is undisputed that the Nippers currently live and work on a 290-acre farm in the Paxton area of Walton County. That's subject to the exhibit from the property appraiser's office that was presented by staff. And I'd like to ask you to turn to tab 1 of the notebook I've provided. This is simply the State Department of Transportation's approval for a private airport for the Nippers. It indicates that, to the best of FDOT's knowledge, that there is compliance with local government regulations. However, I would note that in the bottom paragraph, it certainly does not create any preemption or waiver, simply acknowledging to the board that this is a registered airport with the Department of Transportation. If you'll turn to tab 2, you'll see the very first notice indicating that staff believed that there was a violation of the code relative to the Nipper property, again dated February 1, 2011. The highlighted portion of this notice says specifically, you are operating a commercial business in a land use that does not allow commercial activity and without an approved development order. The reason I would like to have this be considered in evidence is it seems to demonstrate the evolving nature of staff's concerns with the Nipper property, and perhaps it evidences that this is outcome determinative, not truly a pure analysis of the code. If you will turn to tab 3 of the binder, this is section 20103, and it defines allowable uses under large-scale agriculturally zoned property. Again, not in dispute that that's a category that the Nippers are within. If you flip to the second page within tab 3, it specifically says that limited subordinate commercial activities are allowed. So here we have our first inconsistency. We have a violation saying you can't have any commercial business, followed by a reference in the code that says commercial businesses are allowed. Then we come in the next tab, tab 4, to October 11th, 2012. Here, the nature of the violation changes. There's not an objection to a commercial business. There is an objection to a commercial airport. As the code heard, it seems to be at least not an exact mirroring of definitions on what constitutes a commercial airport. Fortunately, we have what I will introduce to the board as evidence of what constitutes a private airport, and I believe I'll be able to pretty dispositively prove that this is not a commercial airport. If you flip to tab 5. Tab 5 is taken from Florida Statute 330.27, the definition section. And I'd call your attention to subsection 5, which gives greater clarity to what constitutes a private airport, distinct from a commercial airport, which is the position of staff. And specifically within subsection 5, Florida statute says that a private airport may be made available to others by the invitation of the owner or manager. Again, staff's view was that you're simply a commercial airport if you charge people for things.
Excuse me, Matt. Where in tab 5? Where did that site come from?
Florida statute 330.27, Mr. Bowman.
Thank you.
If you turn to tab 6, we can have a little journey through federal law. This is part 119 of the federal regulations for commercial air carriers. And if you go down to the bottom of the first page in tab 6, and then continuing on the subsequent page, there is a specific federal carve-out that's highlighted in subsection 6 that says nonstop flights conducted within a 25 statute mile radius of the airport for takeoff, carrying persons or objects for the purpose of conducting intentional parachute operations. So here, federal law says there is this thing we define as commercial carriage for airports, and skydiving and parachute operations are not within that definition, according to federal law. There's no evidence that at the Nipper property, that 25-mile radius has been exceeded. If you go to the next tab, the Nippers wanted to provide greater clarity regarding that section of Florida statutes that I cited to you, Mr. Bowman. This is an email from Alice Lambert, who's the Airport Registration Program Manager for the Florida Department of Transportation. And in this email, Ms. Lambert, in addition to citing Section 5, which I've previously recited to the board, she says, your facility is considered a private airport because it is only for the use of the owner and the owner's invited guests and paying customers. So there we have an aviation expert with the state of Florida indicating that when you invite paying customers, you are in fact a private airport, separate and distinct from a commercial airport. Tab 8. Tab 8 is a limitation on local government authority to regulate airports, but for zoning. So if Walton County wanted to take the position that they didn't want airports, private airports, for paying customers on a 290-acre parcel in the Paxton area, nothing would stop the county from specifically zoning out these types of private airports. But that zoning doesn't exist. Tab, I believe we're on 9. Tab 9 is simply the reassertion of the violation on July 1st, 2014. And the only point in bringing this to the attention of the board is that there is no new violation that is articulated. It simply references back to the prior violation for commercial airport. If the staff is able to prove to this board that the Nippers are operating a commercial airport, they probably prevail in this hearing. But since there's no new violation, other than the reference of a commercial airport, if this board finds the Nippers are not operating a commercial airport, then it would be difficult to violate them pursuant to that language in the notice. The same is true for tab 10. Again, this is the notice, the third notice for the hearing this evening. And again, the only portion that's relevant for my presentation of evidence is that, again, it references an aforementioned violation. There's nothing mentioned other than that commercial airport in the specificity of the violation stated, as stated by staff, I should say. Tab 11. And there was some discussion of this prior to my presentation of evidence. This is the large-scale agricultural objectives and portions of the future land use element. And if you turn to the second page, subsection 5, it indicates outdoor recreational activities such as, and then it proceeds to list things that are outdoor recreational activities. It would border the absurd to suggest that these are the only outdoor recreational activities. What's interesting is that when we review the transcript of this hearing, in Mr. Dias's first presentation before the board, he said that outdoor recreational activities were limited to these issues. He used the word limited to, not such as. And that is demonstrative of, I think, the misunderstanding that the staff has of the code. So then the question becomes whether or not skydiving is an outdoor recreational activity, such as those other issues. If you turn to tab 12, I'll present to the board the affidavit of Will Succum. Mr. Succum is the president and chief executive officer of Visit Florida. Visit Florida is a state-created corporation that we fund with many, many millions of dollars to promote tourism activities and recreational activities for the visitors of our state. Paragraph 6 of Mr. Succum's affidavit is telling. He said, well, 5 and 6, I should say. It says, Visit Florida recognizes skydiving as an outdoor recreational activity. This is the chief executive officer for the #1 tourism-related entity in the state. And then he goes on to say in paragraph 6, skydiving businesses throughout the state of Florida may become Visit Florida partners and engage in reaching visitors through our programs listed on our site. To be a partner with Visit Florida means that Visit Florida will take taxpayer money and promote the business. So it would seem a little odd for this board to shut down this business when you have Visit Florida saying, we can't wait to use taxpayer funds to promote it. If you turn to tab 13, and I'll ask you to turn to page 3 within tab 13, I simply point to the fact that, the interpretations of this board are limited to what's in the code. There is no provision of the code that bans skydiving. There's simply the assertion by staff that it's a commercial airport, which I think we've well dispensed with. Tab 14. Tab 14 articulates the economic goals and aspirations of the county government. And if you turn to the very last page within tab 14, you'll see policy ED 323. Walton County will develop strategies to promote specific sectors of the economy, including the growing need for aerospace and other airport-related businesses. The county will support and develop an aviation industry target plan to direct specific resources to attracting and promoting these industries. So it would seem a bit odd for Walton County to say it is a stated economic goal of the county to promote airport-related businesses, while then at the same time shutting down the Nipper business. Tab 15, Florida statutes. This is the issue that Mr. Davis and I will litigate in about a month. If you look at section 570.96 in the 2013 legislative session, the Florida legislature preempted any local regulation of agritourism. So if something is agritourism, then it is by definition not regulatable by a county government. The evidence that was presented by staff indicates that this is a farm. It's a 290-acre farm. It's zoned with these property appraiser approved agricultural exemptions. And you've seen the affidavit from Mr. Succum that this is in fact a tourism industry. So on a farm, a tourism activity. I don't expect this board to dive headfirst into the shallow end of the pool and making a determination on what constitutes agritourism. That's probably better suited for a judge, but I simply wanted to make the board aware that this in fact is at issue. Tab 16, the testimony of Mr. Dias. I had the opportunity to take Mr. Dias' deposition in the case, and I simply would refer you to the highlighted portion. It begins on what's labeled page 135. And in this testimony, actually I'll pause. It's only 2 paragraphs of highlighted to allow the board members time to review that. When I see everyone's eyeballs back, I'll know that you've concluded that reading.
You don't have page 137, do you?
No, sir. I think we ventured off into another element of the litigation on page 137.
I was just trying to find the completion of that sentence. Q.
Oh, I recall the answer. I guess we could have Mr. Dias. He indicated that I was actually surprised at the response. He said that you all meet very infrequently as a board, and Mr. Dias in his testimony only indicated one circumstance in which the board had disagreed with staff. But if I'm stating that incorrectly, certainly Mr. Warner can put Mr. Dias on to refute that assertion.
You said the Board of Adjustments.
I'm sorry. Well, I believe that in my questioning I was inartful at that moment. And,
you meant the Code Enforcement Board?
Yes, sir. Perhaps that's why I didn't include it, because of my poor question.
I interpreted it that way, so okay.
I think actually both Mr. Dias and I may have improperly referenced the Board of Adjustments when we meant the Code Enforcement Board. We were 135 pages into this deposition when that question was asked. So I assume now everyone's reviewed that, and it's pretty clear here. This was no black or white issue. Tremendous amount of discretion, and that's why Florida statutes have boards like this of citizens that are able to bring some common sense to these sometimes gray area disputes. And finally, tab 17 is a grouping of letters from neighbors of the Nippers who are supportive of the activity and realize the value that a job-creating business in the Paxton area has on that community. I will spare all of us the experience of putting on all of these people who are skydivers who, by their presence, have indicated support for the Nipper position, because I don't know that it's all that dispositive on the question before you what the neighbors feel, but know that there is sufficient support. That's my presentation of the evidence.
Okay, does someone on the board have questions then for Mr. Gates or Mr. Nipper?
I do.
Victor.
Mr. Gates. Pardon me.
Go right ahead, Mr. Bowman.
Well, I want to ask Mr. Dykes a question. Where in the code would an operation like this belong?
Oh, very well. I guess we're not concluded with our presentation of the evidence.
Jonas Walton, Mr. Chairman. You'll have to forgive me. I don't normally practice law. I am an attorney. I'm also a landowner in North Walton County.
Are you going to testify, or are you going to present?
I'm speaking on behalf of Mr. Nipper as co-counsel. I'll swear in if you'd like me to.
Mr. Warner, would you prefer one?
If he's appearing as counsel and making argument, that's fine with me.
Okay, that's fine.
I will be making statements of fact if you would like me to be sworn in.
Do you solemnly swear from the testimony you would give before this board to be the truth?
Yes, I do.
Thank
By Mr. Davis. The issues in this case, I think, has been confused. We're getting issues of commercial and private confused. The idea that large-scale ag cannot be commercial does not make sense. I am an attorney, but I don't practice. I'm mainly a farmer in the cattle business, and I happen to own 1,556 acres of land in 3 sections, which join Mr. Nipper on 2 sides. So if there's any citizen in the county most impacted by Mr. Nipper's activities, it would be me. I am on a horse all day or a tractor. I've seen his activities. I'm very familiar with them. The idea of something being private and public is very much different than something being commercial and nonprofit. The idea that because I'm running an agriculture business that I can't be commercial does not make sense. I'm in the cattle business. I grow cattle. It's commercial. My cattle make noise. My tractors make noise. My neighbors' timber equipment make noise. Impact other neighbors. The amount of noise made from airplanes is less than an armadillo would scare my horse more than his airplane would scare my horse. So I'm actually shocked this has even reached this level of impact. I don't understand how it's got to this, but it's just a confusion of the argument. Why are we discussing whether or not the airport is commercial? Is immaterial. All large-scale ag is commercial. That's the whole point of it. It's not recreational. And there's a list of, on section 11 that Mr. Gates provided, which is obviously a not exhaustive list, outdoor recreational activities such as hunting or fishing camps, bait and tackle shops, shooting ranges and golf courses, travel and trailer parks, campgrounds, connected to outdoor recreational uses, riding or boarding stables, cemeteries, communication facilities, small engine repair, and welding. That's obviously not an exhaustive list. Nowhere in there does it say riding horses and penning cattle. Nor in there does it say running timber equipment to cut timber. Timber equipment makes far more noise than an airplane. Cattle make more noise than an airplane. When I buy cattle, they're lowing and carrying on, crying for mom. Far more noise, far more disturbance to neighbors than an airplane would make. A skydiver falling down, we'll stop on the horses and look at it, and it's beautiful. It's like watching a rainbow. I don't understand why anyone would have any problem with its land use. And the idea that because it is commercial, that is an issue, does not even make legal sense to me. Because all large-scale ag must be commercial, or it won't be agriculture anymore. You'll go bankrupt. That's the point of it. And so I think we're confusing the issue. Commercial is the antonym of nonprofit. Private is the antonym of public. And we're getting, because something is private, it can't be commercial. And any private business that makes money is, in essence, commercial. And so that's what I wanted to press to the board, that it's just simple logic to me. Thank you for your time.
Thank you.
No questions.
Okay. Any other questions from the board? If not, we'll close this public part.
I want my question answered, Mr. Dyche, if you would, please.
Yes, sir.
Is there a provision in the comprehensive code to allow this type of operation?
There is no explicit provision that would allow this type of operation.
In anywhere in the code or the land development code anywhere?
That's correct.
Okay.
And I have a follow-up.
for
You're
me.
done. Okay.
Hang on.
go ahead.
I think this is probably for JC, one of the code enforcement. Have we had any complaints from any neighbors about this operation?
Yeah, the original complaint was from a neighbor.
Well, that's what I should have asked, is how many complaints have you had?
I couldn't tell you how many. Do you know? It's primarily been the same. Just one official complainant?
Same one?
Is it the same one, or we had multiple? We've had multiple, but we've had just, based off of our case, there's just the one official complaint.
Okay.
Yeah, I mean, and typically we have one complaint. We have heard, I mean, I've heard from people in the area, various people in the area, about this. But I can't give you any precise
Okay.
number.
Okay.
As far as whom I've spoken to, 3 to 4 probably that I've personally spoken to.
One last question, I guess. I don't know if this would be for Mr. Gates or his side, but what would be the limit of this operation? What would it turn into? What could it turn into in terms of paving areas for airplanes, other airplane operations coming into the facility? I noticed that there was probably 60 or 70 cars there parked by the hangar. So the intensity of the operation looks like it's fairly severe. So if you could answer somewhat of a roundabout question, I know, but if you could try to answer that, I would appreciate it.
Well, thank you, Mr. Bowman. I'll do my best, and then I'm sure my client will correct me. If someone were to engage in development activity that you referenced, paving things, building things, constructing things, that, of course, would require a development order. Currently, the airstrip is a grass airstrip, so one does not generally require a development order to go and plant grass. As to the extent of the activity, that is an issue that is often most regulated by the FAA and the Florida Department of Transportation. Of course, you couldn't have 87 aircraft out there flying around because you wouldn't have the permitted airspace for that. And so that is an issue that local governments generally don't regulate. The evidence or the legal support for the position that that's not generally something local governments regulate is the Florida statute that I cited to you that said local governments simply can utilize their zoning powers to say this is where airports may be or not be. Mr. Nipper, did you have something to add to that?
I think Mr. Walker would be able
sure.
to answer that, especially being a neighbor.
I'd like to further answer your question, Mr. Bowman.
Thanks.
I saw the picture presented, and being that I have a farm on the road, I've seen the amount of traffic. But let's think logically. Any economic activity is going to have impact on our infrastructure and on our roads. But if you were to hypothetically think of what economic activity could you possibly conceive that would have the least amount of impact on our asphalt and our highway, I could not come up with one thing that would be someone willing to jump out of a perfectly good aircraft. I'm serious. I'm not trying. It sounds funny, and I think it is funny. I wouldn't do it. I love watching it off my horse. But how much asphalt are we going to really impact by people willingly to jump out of a perfectly good aircraft? And so I understand your argument, and I want to present that. I think the picture is the absolute most amount of vehicles I've ever seen there, and the amount of traffic is minuscule, because that is the road I travel every day, 10 times a day.
Well, my last question is, who owns the planes that carry out this operation? Are they privately owned by Mr. Nipper?
I believe that Mr. Nipper, the question was who owns the aircraft? I believe that the current aircraft that's used, Mr. Nipper has a lease arrangement for, right. But I believe he also owns an aircraft.
I own one small aircraft, or my business owns one small aircraft, and the larger aircraft is leased.
Thank you.
It's a rental.
That's all I have time.
Okay. I got a question.
I'll further that. You'll hear an argument.
I'm done.
What?
In large-scale ag, I've grown many peanuts, many acres of cotton. I know many farmers, My neighbor Gus Andrews does not own a piece of timber equipment, but he cuts timber, but he doesn't own one. I've rented many tractors to grow crops, to lease him equipment as part of business. Anyone that's in construction has to lease excavators, bulldozers, tractors, all kind of equipment. So I understand your argument of who owns it, but I don't think it's really applicable.
Well, my concern was related to 10 years from now, if we have 1,400 different people flying into here is what I was concerned about.
I understand.
Mr. Getz, I have a question. How many aircraft are stationed on the field?
There are 3 aircraft total, but they do not all 3 operate at the same time.
No, 2.
Oh, I'm sorry, 2. My mistake.
2. Is there an A&E on the field? Is there a mechanic? Do you do maintenance on the field?
Mr. Nipper?
Yes, sir, I am. AMP mechanic with inspection authorization.
You're the A&E?
Yes,
Hang
sir,
on,
I'm an
hang on
AMP
just a second.
mechanic with their additional A&P.
Hold on there, hold on. Mr.
Nipper,
Davis.
I'm sorry, you have not been sworn, so I need to swear you in. Do you solemnly swear or affirm the testimony you have given and that you're about to give will be the truth?
Yes, sir, I do.
Do you do maintenance on aircraft other than the 2 aircraft on your field?
One other aircraft I do work on for a friend of mine.
And you receive payment for that?
No,
No. Okay,
I do
thank you.
not. I do not charge for my AMP or inspection authorization services, no.
Thank you.
Got me, my turn.
Yep.
For Mr. Gate, all right, am I understanding correctly that the operations, or I guess the commercial activity on that property related to the airstrip or an aircraft is solely for skydiving, or are there other types of services rendered out of using those aircraft, such as just aerial tours, other things like that?
Yeah, it's a great question, Mr. Lovell. And really the way the Nippers have marketed their business is as an agritourism experience. So it's not just you show up, you get the plane, we take you up, we drop you off, and that's it. The Nippers actually make a day out of it. They prepare food. They demonstrate some of the farming techniques that they use. They share cultural information regarding the long history of military-related activities conjoined with agricultural-related activities. And then, of course, there's an aerial tour and then a skydiving experience. And generally, at the conclusion of the skydiving experience, there's a shooting range that's wrapped in the agritourism day.
Okay, which the shooting range, I think, and I saw the photo there of the shooting club. There's, based on the such as list that we read in there, that is an allowable use. Is the county, is staff objecting to that at all?
I think that's specifically identified.
Okay. All right, the next question, Mr. Gates. Do you acknowledge then that the planning director, as I've read, we've encountered in the past many times, has sole discretion to a large extent on his interpretation of what the Land Development Code and Comprehensive Plan specify?
I would disagree with that statement.
You saying that what we've read in there and what we've seen today, that you disagree that he does not, you disagree in fact to the extent he does not have that leeway?
That's correct, Mr. Lovell, and I would point to Mr. Dias's own deposition testimony, where he says, gee, we get a lot of discretion here, and that's why we have a code enforcement board to figure out whether or not our decisions are consistent.
Well, I think we're saying the same thing, but per the Land Development Code and the Comprehensive Plan and numerous sections, do you acknowledge or not that it does allow the decision, or the planning director to make certain decisions on how he interprets the code to be?
My corollary to that statement is that then this board has to sanity check the validity of those interpretations.
Okay, so that's what you're asking for tonight, for us to do a sanity check. Is that correct?
Yeah, based on Florida statutes.
Based on what
and
Mr. Dice's and previously Ms. Blackshear's decisions have been.
Yes, I believe they've both made an improper decision.
That's what we've boiled out to tonight, is that correct?
Yes, they've made the decision pursuant to their notice that this is a commercial airport. I'm asking you to find that it is not.
Okay, that's why I just wanted to make sure I understood correctly what we're trying to get to.
Mr. Lovell, may I
Yes.
respond briefly? With regard to the decisions of the planning director, as outlined in Exhibit 6, Mr. Dice's letter, and as referenced in the Land Development Code, he is the one charged with interpreting the code, relying upon the comp plan. If there is a disagreement with his administrative decision, the remedy is an appeal to the Board of Zoning Adjustments, which has been deemed by that board to be untimely. So his interpretation stands.
But we have the right to,
You obviously have the right to determine whether or not a code enforcement violation has occurred. As far as reinterpretation of the code, my position is this is not the forum where that is decided.
so you're saying that if Mr. Dias has defined the violation that we see, we have no choice but to find the applicant or the defendant here in violation?
I'm saying that based upon the facts presented here tonight, you agree that the operation, which has been acknowledged, a commercial skydiving operation, is occurring on this land use. That land use is not supported, or that use of the land is not supported by the large ag land use as interpreted by Mr. Dice, and that you should find a violation.
I obviously disagree with that. I think that if this board finds that skydiving is an outdoor recreational activity, then there would not be a violation of the code because Mr. Nipper would be complying with the code by engaging in an outdoor recreational activity.
Okay, I think we're all sufficiently.
I've got one more question.
We could keep asking questions, but I'm going to ask Mr. Davis when we close the public part of the hearing.
This is just a very short one to follow up on one that was asked earlier. Is the complainant in this case Travis Wilkerson a neighbor?
Yes.
Okay, thank you.
I would like to add one thing. You kind of have to understand the rural area that we live in, the distances. My nearest neighbor is over 3/4 of a mile away. Mr. Wilkerson lives 1.2 miles away. You cannot see another structure other than a set of power lines. You cannot see another structure standing anywhere on my property. There are about approximately 1 mile of pine trees between me and the neighbor that's complaining about this. If he stayed on his own property, he wouldn't even know what we are doing.
Thank you.
Mr. Sullivan.
Yeah. I'd like to ask both staff and you, sir. Your exhibit number 8, I guess, where you underline, no county or municipality in this state shall license airports or control their location except by zoning requirements. Now, is it the contention of staff that the zoning of this area does not permit this airport?
Yes, sir.
Yeah. Is it because it's an airport or because you say it's a commercial activity?
The skydiving operation is not supported. Obviously, we can't have a skydiving operation without having the airstrip there. And so, yes. I mean, when I say airport and skydiving, I think they're almost the same as far as the Land Development Code looks at that.
You say they could have a bowling alley, but they could not have an airport?
I don't believe a bowling alley would be an outdoor recreational use.
Pardon me?
I don't believe a bowling alley would be an outdoor
They have
recreational.
a golf course?
Right. As the Land Development Code and the comprehensive plan prescribes, I believe that's one of the uses that was given in the plan.
Right. So, and could they have a drag strip?
I don't believe that would fit within the hypothetical drag strip would not fit into that parameters given to us.
What I don't understand, Mr. Dias, is what you base that opinion on. In other words, is it because of the noise level of the activity that you're concerned about, or is it because of violations of airspace? What exactly makes this activity different from an activity like golf balls flying through?
Primarily, it's based on the language given in the Land Development Code and the comprehensive plan. It gives those uses, the similar uses. You look at that. In my opinion, I do not feel that skydiving operation and use of the planes and so forth do not fit within those uses that are prescribed to give us guidance in the plan.
So we're basing this, if I understand right, strictly on your opinion of the document.
Absolutely, and and the Land Development Code prescribes a process because, as somebody mentioned before, we can't list every conceivable use that would occur. At some point, there has to be some sort of analysis and review of that and a decision made. In this case, I believe that's what was done in 2008 by Mrs. Blackshire, and that's what I did in my letter of 2013.
Let me ask you now, Mr. Davis. If Mr. Dias makes the decision of what constitutes an allowable use, then our role is simply to find whether or not the evidence presented to us describes an allowable use or not. But we can't second guess Mr. Dias and decide that we don't agree with him, this isn't a such as use. Is that correct?
As I understand the staff attorney's position is, and don't let me misstate it, okay? Mr. Dice rendered an opinion that was not appealed to the Board of Adjustment. Mr. Dice, correct me if I'm wrong, but you make those types of calls many times a month.
That's correct.
And sometimes they're appealed to the Board of Adjustment, and the Board of Adjustment reverses or doesn't reverse. As I understand Mr. Warner's argument, that's been done, it was not appealed, so his interpretation should be that which you use. Because that is the interpretation that's been established.
Okay, I'm going to give you one last shot here, Mr. Gates, and then I am going to close the public part of this. So you tell me why what Mr. Davis said isn't going to apply to us.
This is the Code Enforcement Board. You have to determine whether or not the code has been violated. Mr. Dias says that the code does not allow skydiving to be an outdoor recreational activity. Mm-hmm. We're saying we're within the code. So it is precisely why Florida statutes have established boards like yours to determine whether or not there has been a code violation. There has not in this case, pursuant to our argument.
Okay, thank you. Any further statement?
No, thank you.
All right, then.
One more point.
Just more quick one.
Okay.
Here's the other part to this is that, I mean, I believe there is a violation in that you don't have a development order to run this operation. To get that development order, you have to go through the process, which you acknowledged when they went down the road through the TRC in 2008. Well, whether it's right or wrong, the way the code's written, planning director has that discretion to make the determination that he did. So we cannot just override what he says here and say, issue a development order. That's not within our purview or boundaries as a board. So that's the other part of this that I see to be problematic.
Well, if that's a question, the answer is that one would not require a development order for a grass strip. If this board were to take the position that to go plant grass and mow it and then take off and land an airplane on it requires a development order, then that would seem to be a departure from the essential requirements of the law.
Well, I guess I'm questioning whether or not, I mean, it seems to me that an operation of this type, air tourism, whatever it was you call it, would require a development order.
Mr. Lovell, I appreciate that that's your opinion. I don't know that there is a basis for it.
Well, I'm not just saying it's my opinion. I'm asking you to refute why it would not.
It would not because there's been no development. There's been the planting of grass and the taking off and landing of an airplane. When the Nippers have barns and hangars and those things, my understanding is they had a development order for the construction of the actual things that were constructed. I'm sorry, ag exempt when it's a barn or those types of activities. But this would be the first time I'm aware in the state of Florida that the planting of grass and then the taking off and landing of an airplane on it would require a development order.
Okay, and I acknowledge there's some merit to your arguments here, but I think that's an important discussion that this board has to address.
No question that the board has to address whether or not, if this board believes that the planting of grass and taking off and landing of an airplane requires a development order, then of course that would be something that we would have to take up with the circuit court.
Mr. Warner?
I was just going to say that the issue is not the planting of grass. The issue is the operation of the commercial skydiving activity. And as Mr. Dice indicated, and as this board has correctly perceived, it is bound by his interpretations. The path to challenge that interpretation would have been through the Board of Zoning Adjustment, which did not occur. So the staff's position is that you're bound by that interpretation, and that based upon the evidence, we feel the violation has been established.
Okay, no further questions? The public part of the hearing is closed. We're going to talk about it amongst ourselves. Who cares to weigh in first?
I'll start.
All right.
I'll come right out and say, if I was in Mr. Dice's position, this type of use is in the marginal zone to me. Talk about shooting ranges and some of the other things in there. I could see any different person having a different interpretation on whether or not this, aerotourism, or whatever we're calling it, fits in the allowable uses. Again, the problem is to get the development order, we have to go through Mr. Dice and his department, previously Pat Blackshear. And it seems to me that this should be redirected to the zoning board of adjustments, if anymore, not this board.
Could I ask you a question? What would be the basis of the development order? What is being developed? The business?
Yeah, I'd have that same question. I mean, why do you?
Yeah. If he had a private aircraft sitting on his farm and he flew on and off it every day, checking his cattle or his crops or whatever, would it require a development order for that grass runway?
I don't know. That's what I think we have to decide here.
I would think not.
Yeah, but look, that's not the complaint, is it?
Right, it's not.
It says regarding development order required.
Well, I'm gonna be a little protective.
Oh, sorry, yes, sorry,
Okay.
okay.
I work with
Right.
orders all the time.
One
so
at a time.
One at a time.
So it's an alleged violation of both the allowable use and whether or not he needs a development order. But all the evidence they presented has been towards the allowable use.
Keep in mind, he laid out a really good case as to how this has gone from one thing to the next to the next. I mean, what was first reported, morphed into different complaints as we went along. I thought he did a great job of spelling that out. So when you go, well, what's on this piece of paper here? It depends on which piece of paper you look at.
Right.
As to what it is.
That was a very convincing argument. Mr. Sullivan.
Well, to say the complaint is that he's running a commercial operation, and I think we've heard tonight that that is not the issue.
Yeah, the fellow who was his neighbor made a real good argument, right?
Yeah.
That,
Right.
It's commercial, but so what?
Yeah.
Okay.
But what I'm saying is the complaint is no longer the issue.
But Mr. Dias found him, described his activity. If we buy into what Mr. Dias is saying, we have no choice but to find that he's in violation of the Land Development Code.
On the other hand, I think Mr. Getz presented an awful lot of things from the state that indicate that that's not quite so.
It does. It seems like that the county has kind of moved their target as to what they're charging as the case has moved along.
Can I make
Yeah, go on,
put my 2 cents in? You have a situation here where there's nothing in our code that allows this type of operation. You're always going to have new things that come up that should be addressed at some point in time. I don't see that you're talking about an outdoor recreational use. I have a hard time thinking that what they're doing doesn't fit in that category. Just because we don't have anything in the code that addresses it doesn't mean they're doing something wrong. It means that somehow it's going to have to be addressed at some point.
I agree.
We all agree with that. I mean, they didn't foresee when they were allowing horseback riding that there were going to be airplanes someday, or that someday they'll take off for Mars from there. But, we have to, and so we may all agree that we disagree with Mr. Dias, but that doesn't make his decision. We can't just ignore his decision.
That's what we're here for.
That's what we're here for. I mean, if we couldn't do that, then I can't believe they would have even allowed the case to come to us.
I think it boils down to we need to make a decision on whether or not they are or are not in violation for not having a development order.
Well, somebody needs to make a motion and call
Well, we need to deal with both.
No, that's not the complaint, whether they have a
Yes, it is.
development
It
order.
is.
Well, that's what the violation.
Wait, one at a time. We got to do it one
on
at a
the agenda.
If you read the complaint, the alleged violations, they are 2. Section 20103A regarding allowable uses, Section 11000A regarding development order required.
And I see that, but again, the original complaint, when you look at it, it's operating a commercial airport, and everything that they've done since then referred back to the original complaint. And again, that's kind of where I go to the target here is moved, or what they're saying is being done wrong has moved as the case has gone along. I mean, what this says is not what the original complaint was, and not what's been said again and again.
How would you apply for a development order for something that's not in the code?
Right.
They're just not going to, if I were they, I would just not apply for the development order. Hey, they don't need one.
So that's what they've done.
If it was an archery range, would they have to have a development order for an archery range for that?
Well, this development order thing, even the county recognizes that perhaps we're being a little bit too severe in what requires a development order, okay? So, again, I'd suggest that they just don't apply for one and see what happens. But hey, I'm no lawyer and I'm not giving them that advice. Okay, but we're here not to advise them, we're here to find whether or not they're in violation.
I mean, it seems to me like the horseman left that barn because they already applied for the development order. Did they not?
I'm not aware that they did.
2008, in the TRC meeting, that's the first review in the development order process,
And they were denied it, right?
according to that, well.
The first letter, the letter from, in
They
2008.
withdrew.
They withdrew. So they never really did apply, huh?
Right.
Well, then,
Thought they withdrew because the planning director made the interpretation.
Why is a whole nother thing. It's,
yeah, and the fact is, they withdrew, so
right.
how can they be in violation if they never, well,
Well, somebody needs to make a motion.
I'm prepared to make a motion. I'm ready to make a motion.
go ahead, Richard, make the motion.
I move that the Nippers are not in violation and that they, we find them innocent, that's the wrong word, back in the court.
Not in violation.
Not in violation of the code, or of the charges.
I'll second that motion.
Okay, is there going to be any further discussion?
Well, let me make one more point. I mean, I don't have a problem with the operation they're doing up there personally. That's kind of beside the point here for me. It's whether or not how we interpret the code and what how we find Mr. Dyson, Ms. Blackshear's interpretation of it. But, you know, you go to, and we brought up this as a drag strip, but I'm thinking roller coaster parks, water parks, you know, things like that. And those are all outdoor recreational operations, commercial. I mean, I think there's very little argument that they're not. If we're giving the planning director discretion to draw the line, and now we're overstepping that bounds, I mean, aren't we remiss there? I just don't see it.
That's my problem with it. It's like, I don't agree with him, okay? If they call a cemetery an outdoor...
Sorry, but I don't either.
They call a cemetery an outdoor recreational use. Come on now, okay?
I know, that just,
If
I
a
mean,
cemetery...
common sense says this isn't a violation.
But the problem is, even though we don't agree with him, we got to listen to him.
But we all know that from time to time, the county does things that we disagree with, that are wrong. I'll just say it, I mean, the county loses in court from time to time, let's say, just because that's a decision that was made doesn't mean that it was right.
Tom, you have a question? I mean, you got a second? You need to call a question, or?
Well, I'm going to say a little something else. Look, we pride ourselves on not being reversed by appeal, okay? We try to do the right thing, not necessarily the popular thing. I hardly agree. I think they ought to run look at all these people here, right? Clearly it's a well-appreciated and not especially harmful use. Does that give us the right to overturn what he said? Okay, I'll call the question. Okay, all those in favor of finding the Nippers not in violation of either of these charges signify by saying aye.
Aye.
And those opposed, and I'll say aye. So it carries 3-2. It is passed. At least for now, they are not in violation. Thank you. If you guys want to, thank you. If you could clear the halls, we have one further item of business. You're welcome to stay and watch, or you can leave if you like. Okay, and that is, it's January, and we need to, well, I'll give it a minute here to clear up. I'm real happy it went that way, because I think they should. Yep, I couldn't bother you.
I think it's like, you know what, I foresee happening, or I don't see anything that couldn't happen, is they just staff gets their ducks, and they go back
And they find a violation of what they should find.
Yeah. Commercial skydiving activity.
You want your Bible?
We're obligated to leave them here, so you might as well take them.
Yeah, I mean, if they can use them,
Oh, I've got to keep one. I need to keep one for the record. Karen, I have one. I'll keep one of theirs. Because I got to initial them all anyway. Yeah. I got one.
You know.
What's that?
He put him in great case.
Okay, gentlemen.
My decision too.
Enough, okay? One additional business, election of officers for 2015. I will make the formal statement that I am running for re-election, and if not elected, I will no longer serve on this board.
I nominate.
So you're welcome to vote against me, but I just can't go back to be an Indian once I've been a chief. Okay?
I recommend that we maintain the officers as.
And Dave, you're the vice chairman, right? Okay, all
Even though
those,
y'all disagree with us.
I guess that we just need to vote, right?
Yeah, the motion is to leave the officers as is, and then that's fine. You just vote on that as it is.
Does somebody have to second that motion?
That's it.
Okay, Victor made the motion, would somebody second it, that Dave and I continue to serve in the continuing? No. Well, it dies for a lack of a second. Okay.
Dies for a lack of a second.
All those in favor, aye?
Aye.
We are re-elected.
Boy, that was close.
Thank you. That was narrow. Okay. This meeting is adjourned.
Hey, Mark, why are we hearing this while there's litigation?
Well, the litigation's actually.
It's what?
The litigation involves whether, Matt mentioned it briefly. They're taking a position in litigation that we have no regulatory authority over that business.
Over any of them.
Because it's got out in chapter 3. Related as its definition.
I mean, you know, I thought it did.
My problem is
Right.
I got you. Are you putting somebody though? Yeah, this tends to be a recurring thing. I don't know how they do it elsewhere, but you know, we see these things boiling down to where it's one person's discretion on how they interpret it. There should be, you know, and that's what the Board of Adjustments should be that committee, in my opinion. That's what I stated first. Why this didn't go on the Board of Adjustment to determine if he was correct or not. And in lieu of that, there needs to be some kind of a.
They didn't appeal, sir. We can't appeal something to the Board of Adjustment.
How strong is that thing they waited too long?
Oh, it's absolute. I mean, of course, see, he's stuck with it. He can't.
But someone made the decision that they
In opposition of.
What I'm saying. What I'm saying.
I voted nay.
Yeah, just one sec, I got to send my sense of them, okay?
I didn't want to. Thank you. Yeah.
We're talking. That's for sure.
I see.
Yell at each other every now. We even yell at each other every now. I'm being conceited.
All right.
But hey, if Dave's answer, otherwise,
That would have blasted if Edgewater
the
was
code,
here tonight.
our code.
It's what? Oh, I never have been. In 16 years I've been working. We've
Well, we just make him.
I mean, I'm just saying because
Dwayne's defense, he's stuck with it.
it seems to me like we would have.
Mr. Dice, the reason I voted that way is I need your help on another issue.
Hey, as far as the use, that ship sailed 2 times. 08 and 13, that use sailed. As far as what the use was, this is the wrong form to be.
It's designed, I think, on purpose that way.
The code states very
I
clearly.
can't prove that.
Well, I know.
Interpretation of use, the Board of Adjustments sits in between.
But they missed their chance at the Board
They
of
did,
Adjustment.
2 times. 08 and 13.
Sorry, I didn't know you were. Sorry.
And
I just didn't
wait,
know if
don't
you
go
wanted
away.
to take it with you.
No.
And then we got bamboo trees.
What do you do now? What do you do now? Nothing?
Well, if we take it literally, a parking lot doesn't require DO anymore.
Yes. Yeah. It's, hey,
Are you serious?
I thought it was a bag of marijuana.
Because they didn't feel that's what you need. Bound by.
this is crushed concrete.
Hey, it's close enough.
What's Tom sitting there with a bag of pot?
Thank Colorado.
Big bag.
On this, all he needs
You
is
should
to
tell me,
let
this is wet.
I
He
guess.
doesn't need to let everyone.
Wet.
I have to mark them up here.
Yeah, but we encourage them to do that if we don't want to.
It's concrete.
What is the,
No, it's-
And by the way, Dave, you're 100% right. The ship has sailed 08 and
You want to
13.
look at it?
Yeah.
The ship has sailed back in
Take some of Take some off
I think
dry.
so. What is it
Look,
that,
it's not a job.
and I couldn't
It's
dispute
future
it,
reference.
this is a discussion I should ask before.
Okay.
What is it that triggers a development in the code?
In this case, the parking lot.
Where'd I get it?
Just the park.
The parking lot,
Hangar.
the hangar,
Where's the law?
the use itself, we need a,
I should have done that, they should have heard that first case,
building,
and then I could have shown
spot.
this.
the use itself, we need a certificate of land use requirements for the actual use. We don't have that. Parking lot would require
That's the
development,
election.
and we need to look at drainage.
Didn't the hangar require one? I couldn't.
I couldn't either, that's what I heard.
The fact is, Mark, is that this was the wrong form, because all the debate about use. And the question you read about, I said, they're going to overturn one time, that was directly related to the Board of Adjustments, because I made it very clear. Board of Adjustments, and I think you knew that. The Board of Adjustments is the body that sets to determine, and the code says it very explicitly, the Board of Adjustments is the body that sets to determine when there's a discrepancy between my decision, when I've interpreted very clearly and lays out the process.
Right.
08,
That's what I think.
and the letter I wrote in 2013, at the very bottom, if you read it, it says, by this letter, you have the right to interpret, to. Right.
You asked them to.
So why didn't they, and I mean, I know you're in a difficult position there, I mean, I didn't quite understand, I mean, I probably would have disagreed with this.
The operation-
Why did you refer them to the Board of Adjustments, why didn't they go through that?
The board says it's already been decided, we're not gonna decide. In 13, the board said it's already been decided, we're not gonna rehash that again. It was decided. Your right to appeal ended in 30 days after that 08 notice that you were, that were you.
So that
you didn't-
was the reason.
Right, because of 08, they didn't appeal.
We tried.
I got you. I mean, let's try to get them to hear it again.
And the board says no. I mean, we've already, that's already been decided, you appealed, it stands. And quite frankly, the reason why he's going to court, he's going to court to debate is agritourism. He has not brought up the issue of the use because that ship sailed. He can't bring it back up in court because it's already sailed.
He can't.
It's not
bring-
timely.
what, can't bring one up in court?
The use interpretation is not even part of his court case. Because that's gone, that's behind us. You can't go back to
Can you
revisit
appeal
it.
what we did tonight?
Yes.
Well,
That's not my decision to make.
Would y'all go back and see, because he went down the road initially about, commercial activity, commercial area.
It is commercial.
And there were some discrepancies there, but you'll clean all that up and go back in and specifically get consistent under another violations of a commercial agro-tourism or whatever it is.
What we'll do is we'll let the court case
And
play
then
out.
come back in.
See what happens in the court case. and then take-
Well, and frankly, if the court finds it's not agritourism, they're gonna enjoin what they're doing, because they've admitted that they're operating a commercial activity. So if a commercial.
But let me ask this, Mark.
So he'll enjoin them from doing anything further.
But Mark, but because the Board of Adjustments has made a decision, we're not going to revisit that decision stands, but the use, what the board did tonight, that's in conflict with the Board of Adjustments.
I think we'll have to appeal. I don't think that.
Who has to appeal what?
The county will have to.
Because what y'all did tonight is
It's in conflict with the Board of Adjustments.
That's why I voted the way I voted.
That's me too. I mean,
I
didn't
say
see
that.
I didn't see it other way. I didn't want to.
It's a little,
Quite
I mean,
honestly.
I'll be honest with you, look, I mean, that's what they get paid to do. There's a little bit of sleight of hand, a little bit of bamboozle going on, and we got sidetracked talking about things that weren't even wrong.
see, it's like, the
I
arguments
said we
Richard.
try to keep it away from
Oh,
just
Damn, try harder next time.
because you know what's gonna happen, yeah.
Well, it's like, it's not right, we're continually asked to legislate. Yes, that's what.
That's not, and that is, I mean, humbly speaking, that's not good.
No, it's not. That's what I'm saying.
Your place is,
We had
okay,
that discussion with planning commission just last
and
night.
then, this is my block line. You had this decision, here's the violation. And here's what occurred. The violation is, you're not the right land use. We've got the Board of Adjustments and the staff saying you're not. It's not the right land use. We have, and so then we come before you, this is what's happening, it's not permitted. That decision whether that's allowable use is not for the forum of this board.
Right.
And are you doing it or not? Yes, or are you doing it or not, period. That's pretty simple.
That's my point. I mean, that's my point.
And if you are, we're gonna fine you this month, or we're gonna give you 30 days, 10 days, whatever it is to get it.
Yeah, but not only did we not find that they were doing an illegal activity, we questioned what the interpretation of an illegal activity was. That's what I can't stand.
Because what you guys, if you don't watch out, you'll be duplicating the Board of Adjustments. And in the Land Development Code, it clearly says the Board of Adjustments makes
That's what we did. That's what we did.
Yeah.
That ain't right.
Yeah, but it is what it is.
I'm only
In the
one
future, maybe should I schedule a meeting to go ahead and try to permit the tower, the third tower, as a cell tower?
Okay.
Okay, and they got to relocate. I don't know, we had those 2 meetings, do they constitute?
I don't know if Renee did it pre-app. We need to get Renee there and do it.
Okay, and part of the, and I don't know if it's a separate issue, is the post office has to be relocated.
Right, and I saw Pam a few days ago, and we've been in contact with the state. Essentially, that building agreement can be amended.
Put everything on hold in terms of.
But the county's got to agree to it, the state's got to agree to amend the bill agreement to change, because if we move the post office where Robert wants it, in the center portion and close the road off, that's going to need to change the plan.
Legally, I know. But he told me.
And you do of the DRI.
No. All we need to do is amend the build-out agreement to show that as being a pedestrian, whatever it is.
They're ready to do that. They're ready to try to do that.
And if we told Pam, and if there's some questions, we can get the state involved. She said if you want written clarification, they can do that. I think we know how to process it.
Well, she told me just tonight, just before this meeting, go ahead, do what you can do, what you need to do to make that happen.
But there is definitely, for a while, we didn't know there was a path to do that. There's definitely a clear path to get to amend the bill.
So what do I do? What's the first step I need to take this?
Call Renee, and let's all sit down and talk about it.
Okay, set up a meeting, you, me, and Renee, maybe Pam, and see where we go.
Exactly. And so we can kind of hash that out, and then we can, and if we can do the pre at the same time if you want, after we finish that.
That'd be great, yeah. We'll give them $205 or whatever it is. Well, we just went through that thing. That guy in the back is
Who's that?
Scrubs. That guy is just,
That's why, you know what, this guy ain't worth his thing.
Well, I just didn't want to get thrown away like
Were you here last night?
No, I'm not.
No, I was here Tuesday night.
Absolutely. Every year about April, March, April, it's kind of.
I was here. It's night, but I thought it was more Thursday. Yeah.
Thank you.
Did somebody forget their note? Hey, Tom, you want this saying? Tom, you want this saying? Well, we can't prove it. They can't prove it.
I can look at that. Some of it need the muscle chart.
Can I do it verbally or in writing too? Can I tell you verbally or do it in writing? No. This is the time. Because this is, what do we look, I'm gonna let him hear that. Tell him what's going on tonight? Okay. You park back here?
Yeah, I can stumble on him. He don't know.